Hi, welcome everybody. We will start the webinar right now. So welcome everybody on the employment webinar by Hamdan Al Shamsi Lawyers. My name is Christina Holiday and I'm the marketing and BD manager for the firm. The following presentation is only for educational purposes and will be recorded and may be published in various media without further notice. Our aim is to deliver practical advice on some of the concerns about the changes in the new UAE Labor Law and partake in an interactive group discussion. Please, for all your questions, share them on the webinar chat, and at the end of the webinar, there will be a Q&A session where it will be answered by our experts. I will now hand over to my colleagues, Ahmed Al Khalil, partner, and Mohammed Al Rusan, Senior Associate, to continue. Thank you very much, and welcome Ahmed and Mohammed.
Hi, thank you, Christina. Good morning, everyone. Well, good afternoon now. I think this has been a hot topic, and we've been asked about it quite often recently because of these changes. Now, I'll go straight into it. So this is the new law that will come into effect in February 2022. And as most have seen from the changes in it, the crux of it is the changes are very significant. I mean, some items were clarified because they used to be under Court of Cassation decisions rather than specific provisions in the labor law. The new labor law did give more clarification on certain things, but at the same time, we have some items that will need to be further addressed later on down the line. So one of the things we wanted to talk about was the fact that, and we'll come to this a little later on, is that the executive regulations or the implementing regulations have not come out to date. With these regulations, they normally are the meat on the bone of the law. So they will clarify certain items that have not been addressed in the law, or they will specifically address concerns of the general public. The other item we have to also mention is that we don't know how the courts will apply the new law and the implementing regulations. It remains to be seen because a lot of the judgments and a lot of the law and the applicability of the law we have to date prior to starting the new law relates to how the Court of Cassation has actually handled such cases. So with that, we do have to mention that there are certain items that we need to just qualify and make sure that people understand that this is our assumption and our understanding of the current law. There will be further explanation with the implementing regulations and with the application of the court system themselves. So with this law, there have been quite a lot of changes, and we thought we would handle a few of them. So these are the topics that we would like to discuss today. And I think these are the ones that we've either been asked about already or would like to address them because these we consider are the fundamental changes that will affect all employees and all employers. So we'll talk about the fact that it's a limited contract moving forward, determination provisions, arbitrary dismissal versus illegal dismissal, wage, work categories, non-compete, and fines. And Mohammed and I will go into the details of each one of them as we move along. So, okay. With this one, I thought it'd be interesting for people to know is that the old law had 193 articles. The new one only has 74. Now, we can argue that it is more defined. There are more precise stipulations and provisions within it. However, it did leave a lot of room for clarification. And I think with those, we're going to see these points clarified with the implementing regulations, we hope. So this is what I've actually talked about, which is the executive regulations or implementing ones, and the court system and the practice of how they will apply the law itself. Now, Mohammed, I leave it to you. You had comments at the beginning as well for the introduction, or we can jump into the matter.
Thank you, Ahmed, and thank you everybody for giving us this opportunity to talk about the amendments of the employment law. Actually, Ahmed, before we get start into the details of the key changes of the employment law, I just want to clarify a very important point about the effective date, which is 2nd of February 2022. I mean, after 2 weeks from today, less than 2 weeks actually. So what does the effective date means? The effective date means the date where the new law become applicable on the relations between the employees and the employers. So from 2nd of February, any agreement or any understanding between the employees and the employers shall become invalid or void. We have, of course, exceptions of this rule. The first exception is in the event the employment contract gives the employee more rights or benefits. I'll give an example. If we have an employment contract gives the employee the calculation of his end of service based on the total salary, while the law stated that the end of service compensation must be calculated based on the basic salary. In such event, this understanding will be applicable because it grants the employee more rights and more benefits. The second exception is mentioned in the law itself, which is in the ongoing unlimited contracts. We have thousands actually of unlimited ongoing contracts. All of these contracts will remain valid until 1 year from the effective date. So until the 2nd of February 2023, these contracts shall remain valid, but all the employers and employees must amend these contracts within this period of time. So far, these the only exceptions of the law. Any other understanding or agreement contrary to the employment law must be void or not valid. So now let's talk about the limited contracts, which is the first amendment or the most significant amendment in the new law. The limited contract simply means a fixed term contract, and the law mentioned that this contract as a start point between the employer and the employee will be for 3 years. So the first contract must be for 3 years. After the end of this contract, or at the expiry date of this contract, it can be renewed for the same period or less than this period, which means it can be renewed for 2 years or 1 year. Like we noted that in the new law, there is no limit down specified. So we have question, can we renew the contract for 6 months, for example? We don't have answer for this question now. As Ahmed said, the executive regulation has not been published yet. So we expect this to be specified in the executive regulation very soon. Now, let's talk about the difference between the limited contract and the previous practice, which is unlimited contracts. The main point about the differences will be about the calculation of the end of services. The end of services has not been changed. It is still the same. So the end of service will be calculated based on the term of the service of the employee. Doesn't matter how many contracts this employee signed. I'll give an example also. If we have an employee who worked for 10 years with an employer, let's say first 5 years were through unlimited contract under the previous law. And once this law came effective, there was a new contract for 3 years. And then this new contract was expired and renewed for 2 years. So in total, we have 10 years service for this employee. The end of service compensation will be calculated based on the 10 years, not based on 3 years or 5 years or 2 years, not based on the last contract. It will be based on the total service term. The second point relating the limited contract is what happens at the expiry date of the limited contract. We sign 3 years contract, and after 2 months or 3 months, this contract will become will be expired. So in the event no one sent any notice to not renew this contract will be renewed automatically with the same term and same conditions. But if any party, whether the employee or the employer, wants to end this contract or not to renew this contract, there must be a notice from this party to the other party notifying him for the intention of not renewing this contract. Also, this point not specified yet in the law, and we expect it will be organized in the executive regulation. That's the main points, Ahmed, about the limited contracts. We will discuss also more points once we move forward in the other points.
So the next point we wanted to touch upon is the termination during probation period and after probation period. So in the previous law, the current labor law, anybody within the probation period can be terminated or resign with no ramifications. You are paid that day and it ends there and then. In the new law, there is a distinction between the termination provisions during probation and after the probation as well. And these will be explained a little further. Now, again, there is a difference between the probation period, between the notices within the probation period, which again, Muhammad will delve into now.
Yeah, thanks, Ahmed. So as Ahmed said, the termination during the probation period now has some restrictions. But before that, just let me say something. Like shifting from unlimited contract to limited contract will avoid a lot of termination scenarios or cases. Because now we have limited contract, so any party wants to end his contract can wait until the expiry date, and we have flexibility of extending this contract for 1 year, let's say. So if my contract, for example, will be end after 6 months, I don't need to resign or break this contract, or the employer doesn't want this employee, doesn't have to terminate this employee. The employer can wait until the end of this contract and just send his intention not to renew this contract, and the relation will be finished at that date. So no need for termination. So we avoid the expression of arbitrary dismissal. We can end the contract at the end of its expiry date. Now about the probation period. Before that, as Ahmed said, any person, any employee, or even the employer want to terminate the contract during the probation period, in the same day, the employee can just leave the company and leave the work, and it's done. And the employer can just terminate the contract with immediate effect. Now we have restrictions, and we have several scenarios. Firstly, if the employer want to terminate the contract, the employer must notify the employee within 14 days, or the employer still has the right to terminate the contract with immediate effect, but must pay compensation to the employee equal to 14 days of his salary. If the case is the other way around, the employee wants to terminate the contract during the probation period, we have two scenarios. If the employee wants to move to another employer, in this case, the employee must notify the employer 30 days before the last working day. And the new employer must compensate the current employer for all the expenses paid by the current employer for hiring this employee who break the contract during the probation period. The second scenario, in case this employee wants to resign and leave the country, or not to go to any other employer for any other reason, let's say in the law it mentioned that leaving the country. So such employee must notify the employer 14 days before leaving the work. And there is a restriction. This employee is not allowed to come back to the country and work with another employer for 3 months. These the cases or the scenarios for terminating the contract during the probation period. Let's move forward directly to terminating the contract during its term. We said it's like we will avoid a lot of termination scenarios because now we have fixed term of this contract, but still, what if the employer or the employee wants to terminate the contract during its term, and there will be, let's say, 1 year or 2 years time for this contract. In this scenario, to be honest, it's not clear in the law. In the previous law, I'll talk about the previous law. Now I'm talking about the previous law. In the previous law, if the employee wants to terminate the limited contract, the employee must pay compensation to the employer equal to the remaining time of the contract itself. So if we have 7 months remaining time of this fixed term contract or limited contract, then the employee must pay the 6 or the 7 months as a compensation, or 45 days or 6 weeks, which one is less. So normally the employee must compensate the employer with 45 days compensation. If the scenario is the other way around, the employer wants to terminate the fixed term contract, then the employer must compensate the employee for 3 months salaries or the term of the contract. Which one is less? Normally 3 months, so that the employer must compensate the employee for 3 months. But in the new law, it mentioned that any party can terminate any contract. So by giving a notice, you're not breaching the law. I want to terminate the contract. The employee want to terminate the contract. The employer want to terminate the contract. They have the right to terminate the contract with a notice. And the law capped this notice up to 3 months only. In the previous law, it was not capped. So some employees, they have the notice period for leaving the work 6 months or 7 months even. But at this law, there's a cap, which is 3 months. So any party can terminate the contract, but about the compensation, there is no clear regulation about how to compensate the other party in the event of terminating the contract during its terms. We expect this to be clarified. It might be through the executive regulation, but we expect it will be clarified through the courts, through the practice. And we expect it will be the same as the previous law, 45 days to be paid by the employee in case of terminating the contract, and 3 months to be paid by the employer in case of terminating the contract. Ahmed, I think that's all about the termination of the contract during the preparation period and during its terms. I hope it's clear. If we have questions, we can answer.
Yeah. So I just wanted to add one thing about the costs that the new employer would have to incur in case of termination. It just says cost of recruiting so far in the law. They don't delve into whether that will include, for example, sign-on bonuses. They don't talk about relocation fees and relocation costs. We don't think the implementing regulations will clarify this point, but I think the courts will clarify it later on, because the new employer shouldn't be responsible for somebody's sign-on bonus, for example. But that's just a quick clarification on it. Moving on to the next point. So the concept, the amendment of the concept of arbitrary dismissal. So under the new provisions, the provisions of the new law, arbitrary dismissal does not exist anymore. So to anybody who has been dismissed or who has dismissed an employee in the past, you're always looking at your risk and your financial position when you terminate someone. Now, if you terminated them for reasons outside of the permitted ones under the law, you would have to pay them arbitrary dismissal. And that was up to 3 months salary determined by the courts. This is for unlimited term contracts. Now, under the new law, that term has been removed completely. We have what they deemed illegal dismissal. And this, I think, is a crucial point, which Muhammad will clarify, because it has a very significant difference between it and arbitrary dismissal. The main point being that it no longer has to do with the employee's performance. And I will leave it to Muhammad to clarify that point in specific.
Yeah, thank you, Ahmed. As you said, arbitrary dismissal not existed in the new law anymore. We have illegal dismissal. The word is completely different, and the meaning is different. Even in Arabic is different. And there is a specific situation where we can consider this dismissal is illegal, which is in the event the employee filed a case or a complaint against his employer, and the termination was because of this complaint. That's the only situation where we have illegal dismissal. Arbitrary dismissal was removed. And this is logic because we don't have unlimited contract anymore. We have a fixed term contract. So if we terminate the fixed term contract during its term, then the employer must compensate the employee for the term of the contract or 3 months. So in this event, there is no arbitrary dismissal. The employer has the right at the end of the day to terminate this employee, whether for the bad performance or for any reason, maybe for restructuring his company. Maybe he wants to, the employer wants to appoint someone with more qualifications, or the position for this employee is not necessary anymore. So previously, in the previous practice, it was all the employees, all the terminated employees, no matter what was the reason, the practice in the court was just giving the employees the arbitrary dismissal compensation from 1 month to 3 months, no matter what was the reason for the dismissal, except the Article 120, which was almost, I've ever seen this article applicable in the courts. Which was that where the employer can terminate the employee with immediate effect because of like damages or because of material damage or something. We don't want to talk about the previous law. Let's talk about and focus about this law. So now we have only illegal dismissal, and we don't have arbitrary dismissal. And as I said, this is logic, Ahmed, and everybody, because we don't have unlimited contract. We don't have unlimited contract. We don't have arbitrary dismissal anymore. But there will be a method for the compensation in the event of terminating the contract during its terms.
Okay. All right. So moving on. The next term that we thought was critical has to do with the definition of basic wage and wage. The old law had these definitions, but the new law specified very itemized points. Basic wage is primarily the basic wage you receive. It does not include any allowances or any other allowances. That's what the old law said. The new law goes into more specific definition of what a wage is. Basic remains the same. It's your basic wage. The new law defines a wage to mean any and all allowances that you are paid in addition to commissions and bonuses. The old law did not define this. This was determined by the courts. And Muhammad will go into more details on this, but just a matter of example. Back in the day when you had, based on the old law, for example, you have real estate brokers is a prime example. Their basic wage is 1,000 dirhams. However, they used to earn commissions per month that would be 15, 20, 30, 40, however many tens of thousands of dirhams. Based on the old law, these employees can claim from the employer that their basic wage is the basic amount, which is the 1,000 dirhams, plus the commission. That's how the law used to be. Now, under the new law, this is specifically excluded. So calculation of end of service is now a completely different way, which Muhammad will talk about, and will even give an example at the end of the presentation. So Muhammad, on to you.
Yeah, thank you, Ahmed. This is a very important point. It's in the beginning of the new law, the definitions. As Ahmed said, the change was on the wage definition, not on the basic wage. But this definition of the wage affected the basic wage definition, because it mentioned all the allowances to be counted under the wage, not the basic wage. Previously, as Ahmed said, we used to count the bonus and the commission as part of the basic salary, and this will affect the end of service and make big difference at the end of the term of the service. In the new law now, the wage definition is very long definition, and it includes that all the allowances must be counted as part of the wage. So they mentioned the housing allowances, the transport allowances, travel allowances, overtime allowances. Overtime allowances also, we used to count them as part of the basic salary, and or argue at least before the courts, this is part of the basic salary. And children education allowances, this is part of the wage, not the basic wage. And the last part of the definition of the wage said that social services allowances and any other allowances, and it clarified the bonus and the commission. The law didn't say directly the bonus and the commission, but the law said or stated any percentage that the employee will get because of his work, or any award he get because of his work. So at the end, the bonus and the commission will not be part of the basic salary based on the new definition. Of course, we will see the court practice. This is our opinion. We think that the basic, the bonus and the commission will not be part of the basic salary anymore. This will make a very big difference. As Ahmed said, Ahmed gave an example on the real estate agents. I'll give another example for existing cases I'm handling right now relating to doctors who works on hospitals. I have a doctor, her basic salary is 10,000. But if you see her bank statement since 6 years, the minimum salary she received was 100,000, and it was between 100 and 200. Normally, we used to calculate the average of the salary, and the average in this example was around 135,000. So we used to claim the end of service compensation based on 135,000. Under the new law, we will be able to claim only 10,000.
So basically, it's a double-edged sword. The employer has a better position, the employee might not, and the other way around. And we have yet to see how they will implement this eventually from the court side as well. But the law is pretty clear on this. I don't think there is too much headway that you can play around with this. So we have yet to see what the courts will apply.
Ahmed, in this case, the employees must negotiate with the employers. They need to realize that my bonus and my commission will not be part of my end of service compensation. So if my basic salary is 10,000, after 10 years, I will get end of service compensation 120,000. But based on the previous law, I will get 1 million or more. So they're supposed to negotiate. If they can mention in the employment contract, this advice is for the employees, not for the employers, obviously. They can mention in the contract the bonus and the commission will be calculated as part of the basic salary. This is possible. This is applicable because it gives the employees more rights and benefits.
The next category, I think this was a significant change, and I think it's in the right direction, is that the new law gives more options for types of work. In the past, we only had one category, which was full-time employment. Under the new one, you've got full-time, part-time, temporary, flexible work, and there's a fifth category, which says will be explained or will be stipulated in the executive regulations. Personally, I've heard about them wanting to do something called a condensed work week. So what that means is instead of somebody working 8 to 9 hours, 5 days a week, they can opt as an employee with the approval of the employer to do 10 hours a day for 4 days. Now, whether that's going to be the format that they're talking about in the implementing regulations, we have yet to see, of course. Yeah, that's it from mine. Mohammed, if you had something you wanted to say about this as well.
Yeah, actually, this is not very clear in the law. The law just mentioned in general the kind of the new categories of the work, and they mentioned at the end of the articles in this regards that the executive regulation will specify the method of and will organize this area of the law. But I think this is a very important amendment. This will be reflected on the market positively for sure. For example, we have a lot of small entities, small companies. They don't need, for example, an accountant to do full-time work, 8 or 9 hours, 5 days a week. They might just need an accountant to work for 4 hours or 5 hours, 2-3 days. If we take it from the other side, we have a lot of individuals in the country. They have other responsibilities, such as students or let's say mothers for new babies. They don't have time to work full time, but they need to work. Now they're allowed to sign a contract as a part-time job with the employers to work 3 days or 2 days, 4 hours a day. This flexibility is great in the market, and the risk was, this was previously in some cases this was the practice was existed in the market before, but the issue was if the employees signed the contract with the employer and the employee used to come to the work 2 or 3 days and work 4 or 5 hours a day only, and at the end of the contract, the employee used to go to the court and claim all his compensation based on the contract as a full-time employee. Now the law will organize this area and will organize obviously the other work like temporary work and the flexibility work, the hours. As we know, the timing has been changed. The weekend has been shifted to Saturday and Sunday. Some people, they might want to work on Friday, so the flexibility in this work just reflecting the whole economic situation, and this will be positively reflected in the market. But from a legal perspective, it will be organized, and I'm sure there will be fair or regulations about the compensation of the employees and the salaries who works part-time or temporary work or flexible hours. We will see the executive regulation, and we might talk about it later, but we don't have any details about these specific points.
It's important to note that also with when they come out with the implementing regulations or executive regulations, they will be coming out with templates of the types of documents used for part-time, full-time, and temporary. So we will have a template that is being used by the regulators, so that will give certain clarity as well. Sorry about my voice. It's been a rough couple of days. So the next point, which is critical, is the non-compete clause. So there was some mention within the old law of non-compete, but it was never, I mean, I haven't personally seen non-competes being applied at the courts. And 9 times out of 10, there is one error within the non-compete clause which allows it to not be permitted. And the courts were relatively reluctant to actually apply it. Even the definition of a non-compete, the way we got it back then was, you know, you have to put in a relevant time, you have to put in a location, and you have to put a time limit. Sorry, specific job role, time limit, and the geographical location. This was based on the courts of the UAE's definition and the Court of Cassation's decisions. With the new law, they've actually applied a specific provision for non-compete, and they've even upped the time limit to the time bar actually for up to 2 years, maximum of 2 years. Mohammed, I'll leave it to you to explain more.
Yeah, sure. Thanks, Ahmed. The unfair competition clause is very important clause. There are a lot of cases, ongoing cases, and a lot of previous judgments. If you see the court system, you will find a lot of judgments in this regard. The practice was not very clear. The Cassation Court mentioned that it has to be specified, and that the area must be specified, and the work must be in the same sector, and the limit time for the unfair competition must be also specified, but it wasn't clear. So each judge, based on the situation and the circumstances of the case, decide if there was unfair competition or no. Now, in the new law, it is very good point, and it is very clear point. Even for the people who drafts the contracts, so it's clear for them. Previously, when Ahmed used to draft a contract and wants to add unfair competition clause in the contract, we all have a discussion in the firm. Should we put it for 1 year or 2 years? 6 months, or should we put the unfair competition only in Dubai or in UAE or in the Gulf? So we have so many questions, and every person has his opinion, and the judges also at the end will have their opinion. Now we have very clear point in the law stated that this unfair competition must be mentioned in the contract. This is a very important point, not in the offer letter, not on in a side agreement or any other document. It must be in the employment contract, and this must not exceed 2 years. So you can put 2 years or less than 2 years, not more than 2 years. The geographic must be specified, and it has to be not. You can't say in the whole world. You might say, okay, in Dubai, you can put this clause as you cannot compete me in Dubai or in UAE maximum, but don't go wild. And it depends on the work, and it depends on the clients of the employers, it has to be in the same sector. These are the conditions. And there are restrictions also in the event if the employer terminated the contract illegally or breached the law. So if, for example, the employer terminated the employee without granting him the legal notice, then this clause will be void. And there is another point also, in the event the employer terminates the contract in a way contrary to the law. I mentioned that. And the time limit for filing the case against the employee for the unfair competition is only 1 year from the knowledge time. So it can't be more than 1 year from the knowledge, and this can be proved in the court. And also, the same article mentioned that the executive regulation will stipulate exceptions on some sectors that people will be allowed to compete in these sectors. We will wait and see what are these sectors.
Okay.
Ahmed,
yeah. So next one is talking about the fines. So I was talking to one of our clients today and a good friend of mine about the fact that now there are exceptionally high and scary fines, actually. In certain circumstances, I do think that these fines make sense. Whether they will be applied or not is a different thing. But to scare, for example, employers who don't pay their employees their dues or their salaries in time or within a time frame, there are fines, and some of them go up to 1 million dirhams. They even talk about jail term in certain circumstances. So the fines have definitely been upped a little bit. And again, we have yet to see how the courts will apply this, because, you know, if it's written in the law, sometimes market practice or the courts don't apply it in the same sense. They should, but for other reasons, they don't apply them as severely. So again, most of this will be up to the discretion of the courts or the regulators, but the fines are there and they have been increased quite significantly. Go ahead.
Yeah, thank you, Ahmed. After all of these amendments and changes in the law, there are fines, as Ahmed said. Some of these fines defined clearly in some situations, and some are very general, as Ahmed said. I'll just like mention a few things. That's very important point, actually. In these situations, there will be fines and penalties. In case of submitting any wrong documents or fraud documents, whether from the employer or the employee to employ someone, commit any or prevent the authorized person of applying the law. I'm talking about the officers of the authorities. So preventing them to do their job, there will be a fine. Employed an employee without work permit, this is a breach of the law, there will be a fine also. Recruit an employee and left him without work. We have some cases, unfortunately, we see some people, they recruit some people from outside of the country and then they leave them without work, or they don't hire them. Close the company without settling the employee's rights. and employs underage person, there will be also fine. Abuse the authorities online system, that's the most significant breach of the law. This specifically, this point will lead to the jail. The other breaches will be only fines. And the most important point, which is the last point mentioned in the law, it said that violating the new law and the executive regulation. This is a very general point, very wide. So violating the law or breaching the law or the executive regulation, what kind of breach, we don't know. And this is on both parties, whether employees and employers, and the penalty will be from 5,000 up to 1 million dirham, and it can be multiplied up to 10 times. So if the employer committed a breach of the law with 10 employees or 11 employees or 12 employees, this penalty can be up to 10 million dirham, not even 1 million dirham. So any person finds himself in a situation, they might breach the law or they don't understand the law, they must go back to the law and understand the regulations or ask a specialist if their action is legal or illegal, especially the employers. Most of the penalties against the employers, of course, not against the employees.
Okay, thank you, Muhammad. I thought, I mean, we've handled the articles we wanted to, the provision we wanted to talk to you about, but we thought specifically this Article 68 is of critical importance because this talks about where we stand with previous unlimited term contracts. So the law says that it applies to unlimited term contracts drafted and signed during the term of the old law. That's the first provision of Article 68. Now, what that means is that the provisions of the law in terms of the calculations, in terms of determination, so on and so forth, will apply. There is a bit of an explanation in the third clause of Article 68, which says that the new law gave the option to the employer to decide whether they want to apply the end of service calculation based on the old law or the new law. So the discretion is now in the hands of the employer, not the employee. So if the employer doesn't want to include, for example, commission or bonuses, he can choose to do so, which I do believe that it's an unfair way to move forward, but the law is the law. It wasn't always about it being fair. The law is the way it is. They try to take both sides and see what is appropriate. Now, we thought from this perspective, it'll be a good idea for us to give you two examples, practical examples of the applicability of the law. And hopefully with these two, you'll see a little bit of a difference because I've seen some of the questions they're asking about the calculation of the end of service. So with these ones, this is an example of a situation that we potentially will have. So an individual has a basic wage of 20,000 and he has certain allowances and there's a commission or a bonus. You can call it whatever it is in that employment contract based on specific KPIs and target. On average, the employee is getting 10,000 dirhams extra on top as part of his commission and bonus. Now, based on the old law, you would calculate his basic wage as 30,000 because you have to include the commission and bonus in with the basic wage. So when you do the end of service calculation, it's on 21,000 dirhams per year of service. If we look at the new law, you would calculate his basic on 20, and therefore his end of service will be 14,000 per year. So in this example, it's 6,000 dirhams per year difference. So imagine if you have that real estate broker who's on 1,000 dirhams versus 20,000 dirhams. He's going to get quite a little bit, a lot less in terms of end of service gratuity or bonus benefit than he would have if he was on the old law. And based on Article 68, which we mentioned just a few moments ago, the employer has the right to calculate it on the new one or the old one. And I find it very difficult for an employer. Maybe I'm being skeptical because we are lawyers at the end of the day. I don't see any employer out of the kindness of their heart granting based on the old law. I could be wrong. I hope I am. But the discretion is now in the hands of the employer. It's no longer a matter of law or the courts based on 68. It's the employer who gets to decide. I'll leave the second example to Muhammad to talk about, and this is a practical one we are dealing with at the moment.
Thanks, Ahmed. Shifting from the old law to the new law is a very big shift. This is a very big change, actually. So there will be issues in between. There will be gaps. This is normal in all the laws, all the regulations, especially when we change the complete law. This is the most significant change since, as we said in the beginning, 1980. We're talking about 40 years or 41 years. There were some amendments, but it was like a few amendments. But now we're changing the complete law, so there will be gaps. My example is similar to Ahmed's example, but it is about the ongoing cases. What will happen to the ongoing cases? I have an example that we are working on it actually in the firm, in our firm, where we have an employee who got terminated on November 2021. We filed the case against his employer in December 2021. We were under the old law, the previous law. We claimed all his compensation, including the overtime and the leave days, and we claimed the end of service compensation and the notice period because he was terminated with immediate effect. Let's talk about those 2 points, the end of service compensation and the notice. His notice was mentioned in the contract 6 months, and his employer terminated him with immediate effect. So we claimed compensation for 6 months. And regarding the end of service compensation, his basic salary in his contract was 25,000, while he used to get bonus and commission in average for the last 4 years, 15,000 dirham a month. So based on the previous law, we claimed the end of service compensation based on his basic salary, 40,000, not 25,000. So we submitted the case to the Dubai court, and the next hearing will be on 5th of February for the other party, which is the employer, to reply to our memo. And we are sure the other party will come and say the new law is effective now, and your basic salary is only 25,000, not 40,000, based on the definition of the basic salary. And regarding the 6 months, the law capped the legal notice period for 3 months, not more than 3 months. So we're paying you based on the 25,000 basic salary, and we're paying you only 3 months, not 6 months. From our side, I'm expecting that argument from the other party. They will argue for sure for applying the new law because it's effective. We're talking about 5th of February now, and the case is under the reviewing of the court. From my side, I will argue, or we will argue, we discussed this, me and Ahmed and the other lawyers, the other consultant in the firm, we will argue in this case, we will argue that the relationship between the employers and the employees was started under the old law, and it was finished or ended in November. So the contract was ended, the relationship was ended under the previous law, and the case even was filed under the previous law. Why would you apply the new law on this relationship between the employers and the employees while it was started and ended under the previous law? So this will be our argument. There will be thousands of examples similar to this example, talking about one case, but I'm sure there are thousands of cases under reviewing in the court now. These cases were filed under the previous law, and now the new law become effective. That's why the effective date is very important. So we expect a new judgment will come in the next few months, and we expect the executive regulation to be in details about a lot of points, and we also expect some resolutions to be issued by the authorities to organize some issues and some gaps in between the previous law and the new law. Ahmed, I think this is my example. If we have questions or...
Yeah, so just as a conclusion to it all, again, we talked about the fact that we're waiting on the implementing or executive regulations to come out that will clarify the law. We hope that they will clarify it enough that we won't have to wait for the courts to make those decisions and the distinctions. However, we do have yet to see the executive regulations and understand what the laws themselves, what the courts will do in terms of application within the court system. With that, we'll move it on to questions, and so I will read out a few of the questions. We've received quite a lot of them. So one of the first questions was, can we have a 2-year contract instead of 3? Now, from our reading of the law, it says a maximum of 3 years. Now, whether they will allow 1, 2, or 3 will be under probably the executive regulations and will be based on the templates that we will receive from the authorities when the time is right. I mean, we're hoping we receive them sometime soon because we have to start speculating and anticipating what we need to do with our employees, with the employers, even with the clients themselves. Mohammed, did you have anything you wanted to say on that?
Yeah, I think it was clear in the law that the first contract, the start point of the relation between the employee and the employer must be for 3 years, not more and not less. The clause was very direct, straightforward. It has to be 3 years. That's the first contract. But as Ahmed said, the second contract might be for the same period or less. And as we said, we don't have limit down until now. The executive regulation might specify this, or the form that will be issued by the Ministry of Human Resources will give only 1 year, not less than 1 year. So yes, you can have 2 years contract, but this must be the second contract or the following contract after the first contract. There's a question actually I was thinking about relating to this point. About the ongoing unlimited contract right now, and once the employer and the employee want to sign the new contract based on the new law, is that a first contract still a first contract? So it has to be for 3 years because this employee is work with this employer since 10 years or 15 years, and now wants to sign a new contract. So can this contract be less than 3 years? I think this contract will be the first limited contract according to the law. The executive regulation will clarify this point, but we cannot go more than 3 years for sure. Less than 3 years, yes, but in the following contract.
Okay. We also got asked a question about whether these laws will apply to the free zones. So the law specifies that this law, because it's a federal law, it applies to the whole of the UAE. The exceptions under the law right now are, the typical ones: the government agencies, the police, the military, domestic workers, and the public sector. Now, it will be that certain free zones will be excluded. For example, you have ADGM in Abu Dhabi and DIFC. These were the ones that have been excluded in the old law. The new law will remain to be seen whether it applies or not. Because even if you were in a free zone, the federal law still applied for employees. So, do you have any comment on that?
Yeah, your answer is right. It's clear. This is a federal law, and this is the regulations of the labor law is part of the public orders. So it applies on all the country, including the free zones. The exceptions, as Ahmed said, these are the only exceptions so far we have in the country, ADGM and the IFC. But there is a resolution from the authorities that these specific areas are excluded from the law. If we don't have like specific exception from the authorities about the name of the free zone, then it applies on all the free zone. The DMCC, we're talking about we have 24 free zones in Dubai, I think, and I don't know the number in the whole country. We have Shams in Sharjah, we have so many, the media city, TCOM, all of these free zones under the law, and they have to apply to the new law for sure.
Another question came about the compensation for visa costs or recruitment costs. Again, We don't have a lot of clarification on what these costs and what it will incur. Even another question here was, what if the new employer doesn't want to pay the cost to the old employer? We have yet to see how that process is going to take place. Is it going to be something that goes through the regular courts, or is it something that goes through an application with the Ministry of Human Resources and Amortization? We don't actually know that yet, because the law just specified that the new employer will have to pay it. There was a comment as well saying that maybe they will force the employee just to pay back the old owner. Now, I anticipate that this will be similar to the current law, where it prohibits employers from making employees repay them for costs incurred. Again, we don't know what will happen. We don't have a practical sense yet because the law didn't specify. Hamad, do you have a comment on that?
Actually, you answered the question clearly. It said in the law that the expenses the current employer paid for hiring this new employee. What kind of expenses? It's not clear. It's very generous. So the executive regulation for sure will determine what kind of expenses, just to avoid any arguments and disputes about this point. But we expect it will be the visa. Once an employer appoints a new employee, he might bring him from outside of the country, so the employer pays for the visa, for the flight ticket, for the work permit, maybe for the insurance, we're not sure. And I think these are the expenses to hire them. But what if the employer paid accommodation for this person for 1 year in advance? Is this part of the expenses? There are so many questions about this point. The executive regulation will clarify this point. We're not sure about this point because it's not a legal point or legal opinion. We cannot even give an opinion about this point because the law gave a general point and the executive regulation will specify it.
Okay. A question here is, I'll just read it out. Is the validity of the temporary and part-time contract, shall it remain the same, 6 months for temporary contracts and 1 year for part-time contracts? Again, I go back to the comment that Muhammad talked about, was that we don't have clarity on this. What will be temporary versus flexible versus part-time? This will be clarified, hopefully, in the executive regulations. They will define what a part-time, what a temporary one, so on and so forth, and the timelines for those. Because part-time can be that you come in for 1 hour, 3 hours, or 6 hours. It's still considered part-time. However, with the implementing regulations, we do believe that further clarification will be provided. Muhammad, comments?
Actually, I don't have any comments. You just answered the question. We need to wait for the executive regulation. This is a very, very important and good question, actually, and we're waiting for the answer of this question. And the law itself mentioned that the executive regulation will clarify this point. So in some points, as we said when we introduced some points, we said we expect the executive regulation to specify this point or this point. But in some areas and some points, the law said directly the executive regulation will specify this point. And this is one of the points where the law mentioned directly that the executive regulation will clarify it. So we need to wait for all of these technical points.
Okay. The question is, as per the definition of basic wage, is it the fixed amount which is received on a monthly, weekly, daily basis, including fixed allowances? No. So basic wage is a very specific term here. It just says the basic wage. The definition of the word wage, on the other hand, is basic wage plus all allowances, commissions, percentages, so on and so forth. So that's the difference between both of them. Basic will remain basic. And it will be the one, usually with contracts, when we draft them, we always tell them, it used to be market practice, do 60% is basic wage, and then the rest divided onto allowances. Because if you do not divide it into those specific ones and specifically mention basic wage, the courts will take the full amount as the basic wage. So there is a difference between the basic wage and the word wage as well.
Thanks, Ahmed. I think that's very clear. The basic wage must be mentioned clearly. This is the basic wage, and any other allowances must also be clarified. what employers and employers should do in this regard. They're supposed to specify and clarify all the salaries amounts and what kind of this amount is for. This amount is for the accommodation, this amount for transportation, this amount is for basic salary. It has to be clear that this amount for everything mentioned in the contract, and then the court will take the basic salary as it is, and any other allowances will be part of the wage. As Ahmed said, the definition has been changed from the other side, from the wage. The definition of the basic wage is almost still the same, but the wage now includes all the allowances and gave examples of these allowances, including the bonuses and the commissions, as we said in the beginning.
Yeah. Right. Another one. Sorry, everyone. I just wanted to clarify. I'm going through random questions because we have some on the chat and some in the Q&A. So I'm just going between both and answering the ones that we have the time for. So one of the questions is, if limited term contract validity is 1 year, also after the renewal, and employer wants to terminate immediately with 3 months notice, can it be done? So if you have somebody who renewed after the first 3 years and they want to terminate or end the contract from...
Sorry, Ahmed. I think if I understand the question correctly, we're talking about 3 years contract. This contract was expired and it was renewed for 1 year. And after 3 months from the beginning of the second contract, the employee wants to terminate this contract.
No, employer.
The employer wants to
terminate. Yeah.
All right. Okay. If the employer wants to terminate the contract, the concept of terminating contracts is possible. Always, any party can terminate the contract for any reason. Maybe for personal reason. I want to close, as an employer, I want to close my company, so I want to terminate this employee for any reason, not related to the work, not related to the performance of the employee. But there must be compensation. There must be compensation. Previously, so the employer, yes, has the right to terminate the contract after 3 months. When we talk after when we say after 3 months, then we're saying that the remaining period is 9 months of this contract, because it's a fixed term contract now. So also the employee must get a compensation for the remaining period. The previous law was mentioning that clearly. The employer must pay to the employee the remaining value of the 9 months or 3 months, which one is less. So sometimes the employers terminate the contracts like 2 months before the end of its expiry date. So they pay 2 months. But if it was like more than 3 months, we go to the 3 months. So in this case, we're expecting, if the practice remains the same in Dubai court, the employer has the right to terminate the contract and pay 3 months salary to the employee.
Okay. Another question is, does notice period vary depending on the seniority in the organization? 30 days for less than 5 years, 60 days for more than... Okay, so notice period has been capped up to 3 months. That's the definition within the law itself. Now, whether you want to put 30, 60, 90 is up to you, up to the employer and the employee between them. Muhammad?
Yeah, Ahmed, you're right. That's under the new law. It's capped, as Ahmed said, for 30 days, from 30 days to 3 months. But there's an article said 60 days and 90 days and gave like different period for the termination. This article is about the previous unlimited contracts. So as we said, in the next year, the unlimited contract will remain valid. During that time, as the notice period has been changed, we have 6 months notices in the previous contracts, and we have 3 months, we have 4 months, 7 months. So the new law specified the way of terminating the ongoing unlimited previous contracts were signed before the validity or the effective date of the new contract. So these 30 days and 60 days based on the term of service applicable on the unlimited previous contracts before this law. After 1 year, this article will not be used anymore, or after we renewed all of these contracts. So this article, I think the person who asked this question reviewed this article, and there was a confusion about this notice period. No, the notice period, as Ahmed said, it's 30 days up to 3 months only in the new law, in all the new contracts. But the previous unlimited contracts, that clause regarding the notice period is not valid anymore directly, and it will be 30 days and 60 days and 90 days based on the term of the service with the employer.
Okay. Is it mandatory that we keep basic wage at 60%, or we can keep it as less? So the 60%, 60-40 was never part of the law. This was just market practice and advice from the law, from lawyers and consultants. So there is no minimum requirement for how much the basic should be. That's going to be a discussion between the employer and the employee on what they should, how much they're going to put the basic wage at. For the transition, should the current contract be terminated and a new contract be drafted for the employee? If yes, gratuity should be paid to existing employees entitled to gratuity based on old law. So yes, all contracts will have to be amended. The old one will have to be not terminated, but it'll transition from the unlimited term contract into these templated limited term contracts. Payment of gratuity should not be paid just yet because the relationship has not terminated. There is a way to pay them and then rehire, but that's a longer process, and we don't advise that necessary. But again, like we said, the transition, once the new contracts are out, you will have to sign the new contracts within 1 year. So by the 1st of February 2023, all employees and all employers should be using the limited term contracts, the new limited term contracts as provided by the regulators. Hamad, did you have a comment on this?
Actually, no, if we just can take more questions, because we have a lot of questions, I think, here. So okay. I don't know if we can answer all of these questions. Maybe we need like another hour to answer all of these questions. So if you can move forward to the other question, I'm trying to see the questions also from my screen so I can find.
Yeah. So a quick one, leave entitlement for a temporary contract. We still don't know what that will mean. Because if you're basing it on the end of service, the way it was calculated in the old law, you would just take the basic wage. But for temporary contracts, you might have hourly rates, or you might have a specific lump sum. So that again remains to be seen. Once the implementing regulations come into play, we will have more definitions and more clarity on end of service gratuity, the benefits, so on and so forth. So we don't have the answer to that specific one yet. Even the courts might apply something different to what we normally understand in the current situation.
I think it will be, Ahmed, percentage, compared, if we're talking about 48 hours for the full-time job, and we have someone who works 24 hours a week, then the end of service compensation should be for this employee the 50% of the full-time person. So it will be like a comparative. It will, the executive regulation will specify all of these points, and it will be clear. Maybe it will be based on the days, because we're saying that the full-time employee will get 21 days salaries for the first 5 years, and then 30 days salaries for the next years after the 5 years. That concept is used for the calculation of the end of service of the full-time employee. But now if we have a part-time employee, the law or the executive regulation might come and say the part-time employee will get 10 days for the first 5 years and 15 or 20 days for the next years. It will be based on the hours, and I think they will fix also the hours. So just like to organize the things so the part-time can be also specified for our days, or if we apply also the flexibility of the hours, we cannot say 4 days an hour, we can say 20 hours a week or 25 hours a week. These are technical points, and the calculation of the end of service relating to this kind of new categories of the law and the salaries and the calculation of the basic and the total salaries, all of these points will be clear in the executive regulation. I think, Ahmed, we should, after the issuance of the executive regulation, make another webinar and discuss all of these points are not clear now. So we should do it in the next 2 weeks, 3 weeks. Maybe the executive regulation will come this week or next week, because the law will be applicable after 2 weeks.
Yeah. We got a question here about a conversion from an unlimited to a limited term contract validity will be effective from 2nd February, or will it be actual hiring date from when unlimited contract is signed? So basically, anyone that is going to be hired as a new hire after February 2nd will have to be on the new regulations. There's no two ways about it. Anybody who is on the previous unlimited term contract has till the 1st of February 2023 to adjust onto the new limited term contract. A distinction that has to be drawn here is that in spite of the date of the new contracts and when they come into play, the hiring date is still used for the end of service calculation. So if you were hired in 2018 and you had to change into the new contract in 2022, your hiring date remains back then and your calculation is based on 2018, not from the new contract. Just the distinction between both of those.
Yeah, Ahmed, the direct answer for this question, the effective date 2nd of February will not be the start point for the limited contract. As Ahmed said, we have 1 year. The employers and employees, they have 1 year. All the previous contracts are valid, still ongoing, applicable, but within 1 year must be changed. So if the employee with an unlimited contract renewed his contract to a limited contract in June 2022, so the first day of this contract will be in June 2022.
Yeah. Just got a quick one here. Is it confirmed the new hires from 2nd of February? Yeah. So there's a provision in the law that nobody's permitted to put employees on the new standard or the new law until the 2nd of February. So anybody hired after the 2nd of February will have to be on the new law and the new contracts. We're hoping they will release it before the 2nd so that people do know what these contracts will be. But yes, from 2nd February, all new hires have to be on the new law and the new templates.
Yeah, I mean, that's right. And also there's an article said that not to try to apply the new law before the 2nd of February. So maybe some employers thought about, okay, I will change my contracts now according to the law. No one is allowed to act in accordance with the new law until 2nd of February. That's the very important date. From 2nd of February, everybody can act according to the new law, but before that, it's not possible. The new law was published by the authorities in the official gazette on 20th of September 2021. I'm talking about around 120 days or 130 days, actually, 4 months and 10 days before the effective date. So these 4 months given by the authorities to the employers and the employees only to review and understand the law, not to apply the law, because the employees and the employers and even the authorities itself must be prepared for the new law, must understand the law before the effective date. And I think this is a long time. The 4 months period is a little bit long time. Normally in the other laws or the other amendments, the authorities give only 60 days, but now we're talking about the employment law. The employment law is one of the most important laws in any country, actually, because everybody is under this law, the employees and employers. We're talking about all the people in the country. This law is applicable on them. We're not talking about the real estate agent law, or we're not talking about any other law concerns some like specific people or like small category of people. We're talking about the employment law. So we have 4 months to understand the new law, but applying the law from 2nd of February. You cannot apply the law before this date.
Yeah. Okay, so we got a lot more questions. I'll just go to the last one. If we issue an old contract after 2nd of February and change it later in the year with the rest of the employees, would this be an issue? Yes. So basically, you should not be applying or using any of the old contracts moving forward from the 2nd of February onwards. None. And again, I say this with a grain of salt because they have to give us the templates for the new contracts. If there is no template issued, then we still have to apply the provisions of the new law. 2nd of February is that cutoff point. So no, you will not be allowed to hire someone on the old contracts after February 2nd.
Yeah, Ahmed. I think that the employers and employees should not be under pressure because the authorities will come and clarify all of these questions and points. The Ministry of Human Resources, I'm sure they drafted and they prepared the template of the limited contract and will be published on the authorities website. Anyone can print it out and then register it. We all know that these contracts must be official contracts. The people they asked about the free zones, also the free zones authority will be in connection with the authorities to prepare their template to be in accordance with the law. The parties can draft any understanding and any agreement between them, like side agreement, but they need to be careful that any side agreement must be in accordance with the template of the Ministry of Human Resources employment contract and the employment law, or giving the employee more rights. Any other contrary to the law or to the template will not be valid.
Okay. I think everyone, I'm sorry, but we have to cut the meeting short now. I will put up the email addresses and further information if you would like to get in touch with us. I do apologize we couldn't answer all the questions, and I thank you for your time. If you need to reach out, please do so. Here are our details, and Christina will be reaching out to you as well to give you some information when you need it. Christina, do you have anything you'd like to add?
Hi, everybody. So, no, thank you for your attention. And there will be an email, also a follow-up email with these contact details sent out to everybody who attended tomorrow. So in case you haven't been able to note it down, there will be an email tomorrow for everyone. So please feel free to reach to us, and then we will be able to answer your questions. Thank you so much, everybody.
Okay. Muhammad, anything from your side?
Thank you, Ahmed, very much. Thank you, Christina, for preparing this. Thank you, everybody, for giving us this opportunity to talk about the amendments. And we apologize for any information or any opinion we might give that might be not in accordance with the practice in the future. As we said, the executive regulation is not published yet. The practice in the courts might change many things. We are happy to receive all of your questions and consultation. We're sorry we couldn't answer all of your questions. Our contact details in here. We're happy to answer all of these questions and clarify any point. And I think, Ahmed, we should do it again. We have a lot of people in here. We have a lot of questions, a lot of clarification came through this webinar, and previously from other people contacted us directly and asked a lot of questions. We promise that, inshallah, Ahmed, just allow me to do this. And we will do it again once we get the executive regulation and we get some clarification from the courts regarding the unclear points. Thank you, everybody. Thanks, Ahmed.
Yeah.
Thanks, Christine.
Thank you all for your time. Have a good day and stay safe.
Thank you.